As every frustrated journalist knows, the easiest way for a politician or bureaucrat to avoid accountability is to say they can't comment on something because of privacy laws. These privacy laws exist for a reason, and that reason has nothing to do with avoiding transparency and accountability. And they certainly were not designed to be used as a weapon to shut up legitimate criticism. Sometimes this is a good faith error or a misunderstanding of a complicated set of laws, but privacy laws can be invoked in bad faith or inconsistently. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. You should check out the full disclaimer below, but you should know that I'm about to give you a very high-level overview of a pretty complicated and nuanced subject. And it's more opinion than anything else. And these opinions are mine and mine alone and should not be attributed to my firm or any of its clients. Too often, bureaucrats, cops, and others use poorly understood privacy laws as a justification for inaction. Maybe it's just that they don't fully understand the myriad of rules and the multiplicity of exceptions. I've become a little cynical seeing it happen over and over and over again. Privacy laws are complicated and are often not well understood, even by those people whose day-to-day operations are affected by them. But privacy laws are generally sensible and coherent, and believe it or not, they're laced with common sense. I've read every privacy law in Canada, and I don't think I've seen one in the public sector that does not have what's called a public interest override, or an override where someone's health or safety is concerned. A public body or government institution in the public sector context can disclose personal information without consent if it's in the public interest to do so. There are often other exceptions from the general rule that otherwise requires consent. This was most vividly illustrated in the aftermath of the South Asian tsunami in 2004, when the federal government said they couldn't name Canadian victims or survivors because of the Privacy Act. Families and friends were desperate for news about their loved ones. The Privacy Commissioner and others were pretty quick to point out that Section 8 of the Privacy Act, which allows the government to disclose personal information where it is in the public interest. It says, subject to any other act of Parliament, personal information under the control of a government institution may be disclosed for any purpose where, in the opinion of the head of the institution, the public interest in disclosure clearly outweighs any invasion of privacy that could result from the disclosure, or the disclosure would clearly benefit the individual to whom the information relates. That is potentially very broad. It is also very important to note that a public body has immunity from any liability for a disclosure that is made in good faith pursuant to the legislation. So if a decision maker decides that it is in the public interest to disclose personal information, they can do so without fear of legal liability. In another high-profile instance, a misunderstanding or misapplication of privacy laws may have led to the death of a university student. A university in Ontario a number of years ago did not contact the parents of a student who was in significant distress and at risk of self-harm. At the time, the Information and Privacy Commissioner of Ontario, Anne Cavoukian, and her counterparts from across the country were more than a little upset to see privacy laws used as scapegoats. They pointed out that these laws, without exception, contain provisions that allow privacy rights to be overridden in certain circumstances. Shortly after this tragedy, Anne Cavoukian and her counterpart in British Columbia, David Lukadelis, released a tool for educational institutions on the exercise of discretion to disclose personal information in such circumstances. They wrote, quote, "In emergency situations, privacy laws in Ontario and British Columbia do not prohibit universities, colleges, or other educational institutions from responsibly disclosing a student's personal information, including information about their mental, emotional, or other health conditions, to parents or others who may be able to help in a crisis," unquote. I would add that what they say about the privacy laws of British Columbia and Ontario apply to every single other province and jurisdiction in Canada. They specifically call out, quote, "In other words, life trumps privacy, and our laws reflect that reality," unquote. All of this assumes that these failures to act are motivated by a misunderstanding and misapplication of privacy laws. And in cases like this, I think they're probably right. But I often see privacy laws used as a general shield to protect politicians and bureaucrats from scrutiny and accountability. I've seen politicians try to avoid disclosing significant contracts with businesses that may have embarrassing political results, suggesting that it would violate the company's privacy. Companies don't have privacy rights under Canadian privacy laws. It may be that they were using the word privacy when confidentiality was what was meant, but words matter. We've also seen instances where differing interpretations of privacy laws lead to apparently absurd results. For example, in Alberta, some police departments would routinely disclose the names of homicide victims, while other police departments would not, citing privacy laws. I was recently speaking with a reporter who was seeking health-related statistics from all the provinces and territories. Some provinces were more than happy to provide them, while others are refusing to provide the exact same data on the basis that it would be an unreasonable invasion of privacy. Now, each of these provinces have different but very similar privacy laws. These should lead to consistent results, but they often do not. But the tension between privacy and transparency is real. Public bodies and government institutions have an obligation under freedom of information laws to be transparent, but they're also prohibited by those same laws from disclosing personal information that would be an unreasonable invasion of a third party's privacy. And where to draw that line is a real challenge. Shortly after the Medical Assistance in Dying Act was passed, reporters asked each province for the number of times people had applied for it and how many people had had a medically assisted death. The provinces of Nova Scotia and New Brunswick refused to provide those numbers, citing privacy concerns. Now, these two provinces are small, population-wise. The numbers were very low, and there was a real risk of identifying who they related to. The Health Authority in Nova Scotia said they'd, quote, have less concern around confidentiality once there were a larger number of cases, unquote. This makes sense. It's much easier to protect privacy when the numbers are larger. The same thing happened with COVID cases and statistics, particularly in the early days or when looking at smaller regions of the country. There are some examples where public bodies release personal information that is technically already public, but in a bit of a gross way. Some Canadian police departments have been following the lead of some departments in the US with a program called Warrant Wednesday. Each week, they make public the names and details of a select group of people with outstanding warrants. But when they publish the details of people with really minor outstanding matters, that seems to me to be disproportionate and is resorting to social media shaming. Most recently, I saw privacy law used as a weapon to threaten an elected opposition politician. In Nova Scotia, just a little while ago, an elected member of the legislature wrote to the health minister demanding an investigation after a young woman died in a hospital emergency department. The identity of the person who had died was well known in the community and had already been reported on in the media. The elected member of the legislature posted her letter to the health minister on her Facebook page and was surprised to receive an email in the middle of the night from the province's Department of Justice. It reads, quote, I'm writing because I understand that the correspondence, which contains personal health information, has been shared on social media. As I'm sure you would agree, protection of personal information and in particular health information is critically important. While the aspects of the letter that contain personal health information in the correspondence to the minister are protected under the Personal Health Information Act and the Freedom of Information and Protection of Privacy Act, these details are now accessible to the public on social media. I'm drawing that to your attention so you can consider whether you would like to remove personal health information details from your posted correspondence and limit further disclosure of this information, of this personal information. If the personal health information continues to be disseminated on social media, we will consider all available legal options. Unquote. Now, few things sound as ominous as we will consider all available legal options. But you know what? The Personal Health Information Act and the Freedom of Information and Protection of Privacy Act simply do not apply to members of the legislature. There was some debate about whether the fact that the member of the legislature was a registered nurse would affect that analysis. And the answer to that is no. She is not a public body. She did not have that information in connection with providing health care to the young woman. But what trumps it all is that she had the family's permission to write the letter and name the woman. The government apparently did not bother to make any inquiries before sending the threatening letter. Here's the moral of this story. Whenever common sense or humanity seem to bump up against privacy laws, take a close look at the law and its exceptions. You'll probably find that the drafters have designed the laws to accommodate common sense and humanity. And when a public body says that they can't disclose information that would reinforce accountability because of privacy, scrutinize that very closely. Since you've hung around to the end of this video, you're probably interested in this sort of stuff, and you should subscribe. I hope this has been interesting and useful. I try to put out a new video every couple of weeks, so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone you think may be interested in hearing about developments in Canadian tech and privacy law. Thanks for tuning in.